Some big cases coming before the Supreme Court on union labor agreements. They're not the same, and so I don't want to, misstate what each individual case is about here. However, if in fact the cases go the way that the National Right to Work Foundation would like them to go, this would be enormous on behalf of worker freedom in America. Mark Mix, the president of that organization, is on the phone with me right now to talk about it. Basically, Mark, this challenges something called the Abood decision. Sort of broadly, I know I'm painting with a broad brush here, but the idea is that this would challenge the union's ability to claim exclusive representation rights over a collective bargaining unit.
That's correct, Vicki. The 1977 case that the Supreme Court decided called Abood was actually our case, too. We argued that case in 77, and the rationale in that case was that the government unions were doing all of this political work, and we tried to make the same argument then that we're making now, in the sense that their forced compulsory fees ended up translating into forced speech. And so in Abood, the court just couldn't go far enough. They said, well, yeah, you're right. You can't force a worker to pay for political or ideological causes which they disagree with, but you can still force them to pay this fee because they are in these bargaining units where the union is the monopoly bargaining agent representing them. And so therefore, there's a so-called justification for the fee. Well, from 1977 to today, we've litigated a series of cases representing employees in the public sector that basically have challenged this, and we are finally getting back to the point where the two cases where we filed petitions for certiorari today for the court to hear these cases, to accept them and to hear arguments and decide them. The two cases we decide, the first case, the Hill case that you mentioned, would actually attack the exclusive bargaining power that union officials have been granted and jealously guard, for that matter, Vicki, because it gives them incredible power. The second case, the Janus case, is a case that challenges the forced fee structure that come with this monopoly bargaining regime.
All right. So I don't think people really appreciate this. Even in a right-to-work state, if you decide you don't want to be part of the union, you can still, the union can still represent you, so supposedly represent you. Outside right-to-work states, if you don't want to have your fees go to political causes, then you can ask the union to give you a rebate back on that or reduce the amount of fees, or you can be a fair share worker. These cases challenge both of those things.
That's exactly right.
Okay.
So they get to the heart of that monopoly power. Yes, sir. Yes,
you can call me sir. I don't mind. This is about the monopoly power that the unions have. Now, what's more interesting to me, rather than the fees issue, is the exclusive representation issue. I fail to understand how it could possibly be considered constitutional that if I don't want to be part of the union, that the union still has the authority to claim representation over me. How is it that the union still has that enormous amount of authority?
Well, it's a very interesting development. It goes all the way back to the 1930s when our federal labor policy was created. And obviously, the federal labor policy was first for the private sector. And then, of course, interestingly enough, Wisconsin was the first state to adopt the private sector model for government employees. And obviously, you're the first ones to really take a stick to it with Act 10 back in 2011. So it's kind of an interesting history. But what happened under the federal labor policy going back to 1935 was the unions were given this power to be the exclusive bargaining representative so that there would only be a single voice in the workplace. And every single worker was bound by that union, and that union could speak for them singularly. You know, Vicki, if we talk about regular law, the elements of a contract, you have to have a meeting of the minds, no duress, consideration, and it has to be legal. Unfortunately, in labor policy, we've allowed this amalgam of common law precedent to say that a private entity can bind me, they can take my money, they can do it under duress, under the threat of firing, and I would say that probably it's partially legal because the Supreme Court said so in a 1944 case, but it completely runs counter to what we understand as the common law doctrine of agency. Here we've created a situation where it's way outside of the common elements of a contract, but yet somehow we blessed it for the last 80 years.
Yeah. By the way, in right to work states, the reasons why the unions complain about free riders is because they claim the right to exclusive representation. And if you claim the right to exclusive representation, you can't, slice people off and say you're not going to get X benefit or Y benefit. But at the same time, those people who don't want to be members of the union can also not go and negotiate their own compensation packages with the company because they're stuck, whether they like it or not, to be represented by the union. And again, fair share payments and political payment rebates and things like that are a little bit different here. In fact, a lot different. But it seems that exclusive representation is the one that, if you really want to promote worker freedom, you take away the union's power to say to everybody, whether they are union or not, you have to abide by what I decide your compensation is going to be, or what I decide your contract's going to look like, or what I decide, how you're going to manage your timesheet is going to be.
Yeah, exactly. And the bottom line is, if you make that voluntary and workers feel like the union can actually negotiate a better deal for them, they will join voluntarily. That's the real secret to all this, Vicki, is that if these two cases make it to the Supreme Court and they uphold the workers' right to represent themselves and their right not to be compelled to pay dues or fees as a condition of keeping their job, if they decide that they want to join the union and have the union speak for them, they can do that. Nothing's going to stop them from doing that. And that's what the union officials are most scared of. Is if we actually give the workers they claim to represent the choice, like they did in Wisconsin, some of these folks are going to say, you know what, I don't think so. And the union officials are going to have to work for their membership. They're going to have to work to service their members, and they're going to have to be just like the private business out there that has to service their customers to maintain their business.
What are the chances that these cases, either one of these cases, are going to actually be taken up? Because this is not a for sure thing. The court could say that's a hot potato. I don't want to touch it.
Yeah, they could. Well, the interesting part about the Janus case, which is the case on the forced fees, is that's really an exact duplicate of a case that we won in 2014 called Harris v. Quinn, and it really is a continuation of what another case that was before the court that was accepted and argued in January of 2016, a case called Friedrichs out of California on behalf of 10 school teachers that the court accepted and heard oral arguments on. And everybody that listened to the oral argument, everybody who read the briefs, everybody who was kind of reading tea leaves thought it was going to be a 5-4 decision, just like the Harris case that we won in 2014, yet it was going to apply to every government employee in America. And only Justice Scalia's death in February of that year led to what was a 4-4 split decision, sending it back to the Ninth Circuit, where obviously the Ninth Circuit upheld the compulsory unionism aspects of that particular
This
issue.
would actually address government workers. That's important to know, because trying to crack the nut of the government union monopoly has been very, very difficult. That's where most of the union activity seems to have been concentrated in the last couple of decades. Is as the private sector contracts in terms of union membership, they are going and they're organizing. It's much easier to organize government workers, and so that's where they seem to have been focusing their concentration, also their power. But that's a strange place to to be if you are somebody who is not a fan of left-wing politics, to have the government workers essentially being the political action arm of the unions.
Well, that's right. And it's union officials in rare moments of candor. There was an AFSCME union official out in California who said, in a moment of real candor, said, it's kind of neat. We get to elect our bosses. And that's really true. Union officials have been very successful in politics and using their compulsory power, both the exclusive representation power and ultimately the forced dues power that's a derivative of that. These union officials cry these crocodile tears and say, we had this tremendous burden, which they asked for, which they will not give up, which they continue to protect, and then say, we have to have these people pay fees, too, for all this.
So this could be a huge chasm opened up in the power base of government unions, and that's sort of the point of this. Something I do want to ask you about, and that has nothing to do with government unions, but you were telling me during the news break, we have another case in Wisconsin where somebody who is trying to exercise their rights under the right to work law in Wisconsin is having to take the union to court again.
Yeah, we've got all kinds of cases up there, Vicki. In Michigan and Wisconsin, we still have cases in Indiana. It was...
And Indiana passed right to work, 10 years ago?
Well, 2012. They were the first one up there that got the right to work law in February of 2012, and then Michigan, and then Wisconsin, and then West Virginia, then Kentucky, then Missouri. So it's been kind of exciting over the last 5 years. But, unfortunately, we still have to litigate to enforce the right to work law now, because union officials do not willingly inform workers of their rights, their new rights in Wisconsin or Michigan or Indiana or West Virginia and Missouri and Kentucky. They just don't do it. So we have to come in and clean the thing up, and we still have cases in all of those states where workers have been denied. They say, well, you can't quit. You must be a member in good standing. That means membership. It's a very difficult thing, but it's a grind, but we'll continue to work at it, and workers will continue to be enlightened by shows like this and your expertise on this issue, Vicki, frankly, to give them the knowledge they need to exercise those new rights.
We have people in Wisconsin who have been told you got to sign this little card thing here and that, and they think they're out of the union, but they are now still bound contractually to pay fees. We've got a challenge on that. You've got someone who is being told by an exclusive representative bargaining unit that, he's going to be denied his sick leave. All kinds of crazy things are going on in our state, and it requires, if you are someone in a situation that seems a little funky and doesn't sound like it comports with the law, should probably call someone at the National Right to Work Foundation.
That would be great. They can talk to a lawyer for free. It's a 800 call. Just basically call in and ask about your rights. Our number is 800-336-3600, or you can find us on that Al Gore amazing internet at www.nrtw.org.
Oh my, yeah. He did at least one thing right. Yeah. So last thing I wanted to ask you though. And now I've spaced. That's my problem, is that I've completely spaced on this. But I do thank you for your time here, Mark. And, I know what it was. When do we expect the Supreme Court to decide on cert?
Well, we expect they're going to be done with their term in June 30th. They will go out, and we expect that they would come back and conference these two cases, two petitions for certiorari, probably likely in September, toward the end of September.
So fall, no decision until fall. You have, are you confident that both of these cases are going to be taken up? Are you more confident about one than another?
Well, Vicki, I hope that both get taken up. You never know. I mean, the Supreme Court, I think, if I remember the statistics, gets between 8,000 and 10,000 petitions for certiorari in each term, and they grant like 100 cases.
Yeah, they could double that, by the way, if they wanted to.
Yeah, it's a difficult road. But this case seems to be of particular interest to a set of justices, and we're encouraged that they took the Harris case. Well, they took the Knox case in 2012, which was a case that got us to the Harris case, which they took in 2014, which got us to the Friedrichs case, which they took in 2016, and the Friedrichs case sets us up for this case, hopefully. So.
All right. So baby steps or stepping stones or lily pads or whatever you want to call it here. We will find out in September. Thank you very much for continuing the fight, Mark. I appreciate it.
Thanks, Vicki.
From the National Right to Work Foundation, Mark Mix. He is the president of that organization. If you do have problems, because Wisconsin's the new right to work state, and your union is telling you you can't do X, Y, or Z, or somehow that if in fact you leave the union, that if the union has exclusive bargaining rights at your company, that you're going to be left to side when it comes to sick leave or vacation time or something like that. Not true. Make sure you make contact with the National Right to Work Foundation. We'll be right back.